Everyone. I'm Jennifer Lowe. I'm the Director of Programs and Strategic Planning here at the Supreme Court Historical Society. I am delighted to welcome you to our virtual platform for today's program with Professor William Casto, who is speaking on Chief Justice Oliver Ellsworth. Today's program was developed in response to the feedback from our members, who, in response to the surveys we circulate following each of our virtual programs, have asked for programs on the court's chief justices. We will continue to develop these in the coming months and years. Now, for our speaker, Professor William Casto received his law degree from the University of Texas, Knoxville, and a Doctor of Science of Law from Columbia University. He joined the faculty at Texas Tech Law School in 1983 after practicing law in private practice for a number of years. He is a member of the American Law Institute and holds the Paul Whitfield Horn Distinguished Professorship, which is the highest honor that Texas Tech may bestow on a faculty member. He is currently writing a book on the process of providing legal advice in government. He is the author of 3 well-received books: The Supreme Court in the Early Republic, Oliver Ellsworth and the Creation of the Federal Republic, and Foreign Affairs in the Constitution in the Age of Fighting Sale. Professor Casto has written articles on judicial review, foreign policy, and the relationship between religion and public life in the founding era. We will be taking questions from the audience. Please drop your questions into the Q&A box on the Zoom, and we will get to as many questions as we can. Professor Casto, the floor is yours.
Okay, well, great. Hello, everyone. I want us to talk about Ollie Ellsworth today. But by the way, when he was growing up, his parents called him Ollie. And he is clearly an influential member of the founding generation. He was on the 5-member committee of detail that roughed out the U.S. Constitution. He participated in many of the important compromises in the Constitutional Convention. After that, he was in the Senate for 6 years and was the de facto Senate Majority Leader. Finally, George Washington appointed him to the Supreme Court, where he served from 1796 to 1800. By the way, he doesn't fit our usual vision of the founding fathers. In fact, he was a born-again Christian. A born-again Christian on steroids. And his Calvinism, he used Calvinism to organize his entire life. Now, he was born in 1745 into a prosperous but not wealthy farming family in Windsor, Connecticut. His older brother got the farm. His parents intended him to become a minister. His parents were what were then called New Light Calvinists. So he was educated before college by the colony's leading Calvinist thinker, a fellow named Joseph Bellamy, although who really cares what the guy's name was, right? His parents sent him to Yale, where he would be educated and become a minister. But, you know, in modern times, sometimes college campuses are a little chaotic. Well, that was clearly the case at Yale. The year before Ellsworth matriculated at Yale, the students got very angry with the strictness of the college, and so they beat one of the tutors with clubs. Tutors being like a professor. And then they rioted and they shot the tutor's windows out with pistol fire and shot out the president's windows also. Well, Oliver arrives the next year, and he seems to have been a bit of a hellraiser. He was fined a number of times by the college for doing things like leading crowds in the college commons or providing wine for dinners and that sort of thing. In his sophomore year, someone adulterated the food of the college, and all the students became violently ill. No one died. Well, that was enough. His parents withdrew him from Yale, and he moved south to the College of New Jersey, in New Jersey, by the way, which now is Princeton University. Well, he did well at Princeton University. After he was graduated, he did a year of postgraduate study with a Connecticut minister who was known for preparing people for the ministry. But then a funny thing happened. Ellsworth decided, I don't want to be a minister. And he became a lawyer. And by the way, he then happened to marry the daughter of one of the most influential families in all of Connecticut. And his rise was meteoric after that. Not unfortunately, but as a fact, you have to understand a person's philosophy, assuming they have a philosophy, and Ellsworth did. You have to understand his philosophy in order to understand what made him tick. And by the way, Calvinism is what made Ellsworth tick. And here's the thing. He was utterly driven by something called New Divinity Calvinism, an extreme form of Calvinism. By the way, I'm not really a religious person myself. I have a lot of trouble grasping how this system works. But when I say it's extreme, I mean he believed in absolute predestination, that everything that happened on this world was predestined by God. And by the way, I mean everything. Like, for instance, do you see I'm raising my hand? God made me do that. God predestines everything. And, God was an omnipresent and all-powerful God. Hey, even common murders were predestined by God. Everything was predestined. I don't see how that system works, to be quite frank. There seems to be no room for free will in that system. But a real capable philosopher named John Rutledge, another Calvinist minister, came up with the idea of what really counts is what you're thinking when you do something. Going from the book of Matthew, you're supposed to love the Lord thy God and love thy neighbors as thyself. If you're thinking about that when you do these predestined things, you're right. If you're not, you're wrong. Now, and notice, again, this becomes a little weird in my mind. Do you see there's no room for good works in Ellsworth's view of the world? Man cannot possibly earn his way to heaven by good works because everything is predestined. And so he believed that, God has selected or elected certain people for salvation. And those people were on the road to heaven. In Ellsworth's church, in the manuscript parts of the church, there was an asterisk beside the names of the people who had been elected by God. Ellsworth was elected, of course. His mother was. His father was not. Now, here's the strange thing. You'd think such a severe Calvinist would have trouble negotiating deals, but Ellsworth turned out to be a master negotiator because, notice, he was utterly principled. He strove for what in his mind was right, or he was thinking what was right, but he had no problem whatsoever compromising his principles because he knew that the resulting compromise was part of God's plan. And so he was a firmly principled fellow who was quite willing to compromise his principles because he didn't see it as a compromise. A good example is the compromise on slavery. Ellsworth, like all New Divinity people, was utterly opposed to slavery. Yet, when he served on the 5-person Committee of Detail in the Constitutional Convention, he agreed to a provision that would forbid Congress from outlawing the importation of slavery. In other words, he helped Southern slave owners. What he had in mind was he believed that that South Carolina and Georgia would walk if this provision supporting the importation of slavery were not put in the Constitution. And so he wholeheartedly supported it, knowing, by the way, that he had a love of God in his mind and love of his neighbors, which, by the way, New Divinity Calvinists included slaves as their neighbors, okay? But he knew that the compromise had been preordained by God, and so he had no problem whatsoever. Hey, okay. I was fearful that I'd lost track of the time for a second there. Hey, there are other compromises in his political career, and he was noted as an extremely capable person working in legislative assemblies. He could make deals right and left. At the same time, he was utterly principled because he knew that any deal he made was part of God's plan. I'm going to skip over the Judiciary Act. Let's go to him as Chief Justice. It's kind of strange here. John Jay resigned in, I think, 1795 as Chief Justice. And then it turned out, maybe it was 1794. Then George Washington appointed a friend, John Rutledge, as Chief Justice. Rutledge was a recess appointment. When Congress came back into session, the Senate did not like Rutledge's politics and did not confirm him. So then George Washington turned to Patrick Henry. And Patrick Henry said, no, I don't want it. And so then George Washington turned to William Cushing, who was an associate justice, and Cushing said, "No, thank you." And so in desperation, the president turned to Ellsworth, and Ellsworth accepted, probably as a matter of duty. Okay? Here's something very strange. Ellsworth viewed his job as Chief Justice to seek with ardor the felicity and glory of George Washington's administration. He saw himself as part and parcel of George Washington's government. And so he tried to support it as best he could. By the way, do you see in terms of predestination, there's very little room for separation of powers in predestination. There's no room for checks and balances in predestination. It wasn't necessary. Ellsworth believed that the federal government was part of God's plan, and he was damn well going to support George Washington. For example, he frequently gave advisory opinions on crucial issues in government, like when he was first Chief Justice. Congress was raising hell with George Washington. They wanted George Washington to hand over some executive papers relating to a controversial treaty. Ellsworth wrote an 8-page advisory opinion for Washington saying he didn't have to do it. Washington then, using that 8-page opinion, advised. Washington didn't cite the opinion, but his argument was based on the opinion, advised Congress, I don't have to give you this information. Later on, when Congress made seditious libel a crime, the executive branch asked Ellsworth for an advisory opinion on whether seditious libel was constitutional. And he gave an opinion saying, oh no, it's constitutional for the following reasons. By the way, Ellsworth would probably have been presiding as a trial judge over some of the seditious libel actions. Ellsworth also was very happy to write grand jury charges. And when you think about a grand jury charge, what could be more boring? Here are the elements of murder, right? No, in those days, grand jury charges were viewed as political doctrine. And the justices on the Supreme Court would deliver grand jury charges with the understanding that the charges would be published in newspapers throughout the nation. And so their grand jury charges tended to be political statements. Again, the seditious libel arises. A member of Congress, when the seditious libel action was passed, made a very strong argument. His name was Wilson Carey Nicholas, made a very strong argument that seditious libel was unconstitutional. Well, after that argument was made, Ellsworth drafted an extensive grand jury charge to be published around the nation, explaining why Nicholas was wrong, and he delivered it. By the way, he also served as a diplomat. He got together. At this time, we were in an undeclared naval war with France, and Ellsworth agreed to, in private conversations with President Adams, the two men agreed they would send a commission of 3 people to France to negotiate a treaty. and Ellsworth would be the lead negotiator of the commission. And he did that. He went over there, and negotiated a treaty with France. But a strange thing, an unfortunate thing happened during the late 1790s. Essentially, America has always been a pluralistic society. And so there was constant chaos in which different political parties were stridently opposing each other. There was no system to the United States government. It was divided between the Federalists, Ollie being a Federalist, and the anti-Feds led by Thomas Jefferson. It was all chaos. Do you see that's utterly inconsistent with the notion of a society ordered by God? Ellsworth apparently decided that the federal government was a dead end. And he apparently decided, consistent with Calvinist doctrine, that the reason that God created this federal government was to educate American people on why chaos was so undesirable. Upshot is, Ellsworth resigned. He returned to Connecticut, but he said he had health problems, but for 8 more years, he served in all levels of the Connecticut state government, Connecticut being a very orderly state, cleaving to Calvinist principles. When Thomas Jefferson was elected, Jefferson invoked the legend of Sisyphus. You know, the guy who had to roll stones up a hill, and he'd get to the top, and then the gods would have the stones go back down, and he'd have to roll them up again. Ellsworth said, so the anti-Feds are now to support their own administration and taking a turn at rolling stones uphill. So that's a brief talk. I'm open for questions.
Wonderful. Thank you so much. So one question we had from the audience is, why were people so reluctant to be Chief Justice? Why were people turning the job down?
Well, it's not, well, here's one of the problems. Do you see, we are used to the Supreme Court holding session in Washington, D.C., and the justices all live there, and, you know, they take the metro down to the court. I bet they don't now, unfortunately. But in that era, of course, the Supreme Court met at the nation's capital, but most of the work had to do with trial courts spread around the United States. And in those trial courts, they would be composed of the local federal district judge, you know, the person that we all know now, and a Supreme Court justice who would ride circuit. Think about it. There are no airplanes. There are no interstates. You see how rigorous it was to ride circuit around the United States? I think that made the job pretty onerous, to be quite frank. To be sure, there's some glory in the job, but wow, horseback and wagon carriages, wagons breaking down, that was not pleasant. That's my take on why they didn't want to become Chief Justice or on the court.
Thank you. Another question from the audience. What was Chief Justice Ellsworth's relationship like with Chief Justice Rutledge? And did that tumultuous appointment of Rutledge have any impact on how Ellsworth approached his time on the bench?
He, of course, knew Rutledge because they had served together, I'm pretty sure, in the Continental Congress. Notice that Rutledge was not a Calvinist, right? He was I don't know what his religion was, probably some type of Protestantism from South Carolina. He was not God's elect. And yet, here's the interesting thing. Ellsworth had no problem whatsoever comfortably dealing with and working with people who are not God's elect. Back in his hometown of Connecticut, most of the people in his church were not of God's elect. Oh, by the way, if you were of God's elect in his church, you could take full communion. If not, not. Also, only God's elect could vote on church matters in his church, okay? Do you see most of his neighbors were not elect, but he got along quite well with everyone. He was used to dealing with people who had not been elected by God for salvation. Under that approach, Rutledge would have been the same as a tavern keeper back in Windsor, Connecticut. And Ellsworth could deal with Rutledge pretty well. He probably thought that I'm pretty sure Rutledge was a slave owner, okay? He probably believed that Rutledge was an immoral and bad man, not because Rutledge was a slaveholder, but because when Rutledge did what slaveholders did, Rutledge did not have a love of God and of his neighbor in his mind. So I'm not, frankly, aware of any correspondence between Rutledge and Ellsworth. So it essentially was all political.
Thank you.
John Jay had negotiated an extremely controversial treaty, okay, called Jay's Treaty, okay? Rutledge appointed in a recess appointment. And then Jay's Treaty came out, and there was a mob that raged throughout Charleston, South Carolina for 3 days. And at the end of the mob, Rutledge gave a rabble-rousing speech decrying the Jay Treaty. Well, when he came up for the Senate to approve his full-time appointment, they voted against him 20-10. The same people who voted for the Jay Treaty voted against Rutledge. The same people who voted against the Jay Treaty voted for Rutledge. So in other words, gosh, have you ever heard that sometimes maybe Supreme Court appointments are political? That was so big time in 1795, 96, when Congress said, we don't want that guy on the Supreme Court.
Right. Thank you. So what intrigued you that made you want to study Justice Ellsworth? That's come up a couple times in questions.
Yeah, I was a relatively young professor, and I was looking around for something to do. And I've always been a big federal courts enthusiast. And I knew about the Judiciary Act of 1789. And then as I was noodling into that, finding some records of what was going on in Congress and that sort of stuff, I figured out that Ellsworth had written basically the Judiciary Act of 1789, along with another fellow senator named Patterson. And I also discovered that there was no adequate biography of Ellsworth. So, damn, I'm going to have some fun reading that. And as I said, I am not a religious guy, but as I studied Ellsworth, I came across this strange new divinity Calvinism and how it utterly ruled Ellsworth's life. And so I became very interested in that to figure out what made the guy tick. And by the way, when I say it ruled his life, he would quote New Divinity Calvinism in pamphlets. When he was 50, he was when he was 50, he wrote, it was a committee that wrote a summary of Christian doctrine that laid out New Divinity Calvinism. So I just became very intrigued by that. It just as like an unexplored forest, and I enjoyed exploring it. By the way, Ellsworth, needless to say, fully supported the establishment of religion. Although he was chairman of the Committee of Conference on the Bill of Rights, and the Establishment Clause in our Bill of Rights today appeared as Ellsworth's handwriting, that a change that Ellsworth put in. Here's the funny thing. Connecticut had what we all would all say an establishment of religion. They taxed everyone in the state for the purpose of paying Calvinist ministers their salaries. It was also illegal to deny the Holy Trinity in Connecticut. It was illegal to deny that God ruled, our Christian God ruled the world. But Ellsworth, notice from Ellsworth's point of view, he doesn't want the federal government horning in on the Connecticut's establishment. And so he wanted to have a First Amendment religious clauses that would keep the federal government out of the state's hair and allow them to have their establishments if they wanted to. But by the way, obviously that's radically different from what we do today, right? Notice that doesn't come from the First Amendment of the Constitution, our understanding of the Establishment Clause. Today it comes from the 14th Amendment, which clearly was put into the Constitution to regulate states. So yeah, he's just it's like a interesting puzzle. You get all these pieces together of your puzzle and you fit them all together. And if a piece doesn't fit, you think, oh, I better change my idea of what the puzzle is and so forth.
Right.
It's fun. It's fun.
To follow up on the question about Connecticut,
Yeah.
They had an official state religion at that point, right? But was there also a religious test to hold office at that time?
They had it was not declared an official state religion. Rather, the state collected taxes from people and paid the taxes to ministers who were established. And it's the Calvinist ministers who were established. And they forbade the collection of they forbade people from denying the existence of God. In other words, they didn't establish Calvinism formally, but everyone understood what was happening. Now, on test, here's something, the original Constitution had a test oath. Forbade a test oath to hold government office, okay? Ellsworth wrote a series of pamphlets supporting the ratification of the U.S. Constitution. Like Publius, except his was called landowner or landholder. Yeah. And he said you didn't need a test oath was not appropriate. One thing he pointed out was that if it's a test oath, first of all, he referred to John Locke and said, "Hey, heaven should decide whether people are doing the right thing or not, not a state." And he also said, "Hey, if we're going to have a test oath, then who's going to say that it's going to be a Calvinist test oath?" There's so many different, he recognized the existence of different religions in the United States, different brands of Protestantism, of course. Oh, by the way, he didn't view Catholicism as a religion. It was a work of the devil, okay? But he said any test oath is if it's based on a particular branch of Protestantism, would be wrong to impose on people who are not of that branch of Protestantism. But notice, he was a thoughtful man. He said, some people might say, all you have to do is a test oath that says that you recognize the existence of a God. And his response was, well, the problem is we look at, we hate England's establishment that required people to take an oath in order to hold public office and to have official positions. That's outrageous. Moreover, you have to understand this, that the only person that will be harmed by a test oath would be a person who conscientiously does not believe in test oaths. That if people actually did not believe in God at all, they would have no problem just lying about it. That was the argument he made. It made sense to me, especially the notion that a test oath requiring people in one state to take a test oath that followed the religion of another state, that's a powerful argument. So.
Thank you. Today is the 222nd anniversary of the court handing down its opinion in Marbury versus Madison. Mm-hmm. Since Chief Justice Ellsworth was the author, one of the prime authors of the Judiciary Act of 1789, did he have any thoughts that he has shared publicly with anyone on Marbury versus Madison and judicial review?
I don't know about Marbury, what he thought about Marbury, okay? In a sense, he basically swore off the federal government and said, this is a dead end, a cul-de-sac in God's plans. But he hasn't left any clear statement or analysis justifying judicial review. But in the ratification debates in Connecticut, he said that, hey, if Congress should pass an unconstitutional law, the courts would simply say it doesn't count, it's unconstitutional, and they would set the law aside. So he thought that there was a judicial review. And by the way, almost everyone that I've read from the 1790s more or less agreed that an unconstitutional act of Congress should not be viewed as a law, okay? But he hasn't left any detailed explanation. There's a guy named James Iredell who was on the court who left an incredibly and powerful justification of judicial review, far stronger than Marshall's opinion. And he agreed there should be judicial review.
Thank you. Going back to the Constitutional Convention, what was Ellsworth's most important contribution to it?
I would say his most important contribution was that, there was a great controversy in the convention as to how to allocate members of Congress. Should each state have members of Congress allocated according to their population, which we've all heard this, right? Which the big states wanted, because that way they would run the Congress. The small states, however, said, no, we'll be shoved aside if it's done by population. Ellsworth's Connecticut was sort of in the middle. It was kind of a largish little state, small state. And he and his friend, Roger Sherman, came up with the idea, we'll have a compromise. We're not surprised that Oliver Ellsworth failed a compromise, was in favor of a compromise. And their compromise that they suggested is the one we have today. Each state has 2 senators, the House of Representatives apportioned by population. Ellsworth was a vigorous supporter of that, and he was the person who made the motion and made the basic arguments. I think the idea probably came from Roger Sherman, who was Ellsworth's mentor from Connecticut. That was the most important. And by the way, do you see the purpose of that compromise was to prevent the convention from collapsing and the states walking. It was necessary in order to reach an agreement that could be proposed to the people. Similarly, do you see his compromise on slavery? He viewed as necessary to keep South Carolina and Georgia from walking. And in order to preserve the federal system of government, he was willing to back the slaveholders in South Carolina and Georgia, always knowing in his mind that he was thoroughly opposed to slavery. It was evil, but he was doing it to further the idea of a constitutional government, which he viewed as part of God's plan. So those were two. I think he was the guy in the Constitutional Convention who said it should be the United States, should be the name that we adopt under this Constitution. Those were the two major compromises.
Great. Thank you so much. And just a reminder to our audience that they can drop questions into the Q&A box. So my next question from our audience is, did Ellsworth have a role in drafting the Alien Tort Statute as part of the Judiciary Act?
Yeah, yes, he did. He drafted it. Oh, and it has to do with, somehow it fits into another compromise in the Judiciary Act. You know, the most important treaty in American history was the Treaty of Paris in 1783, in which the British said, recognized us as an independent nation. And part of the deal to get that treaty was Article 4 of that treaty, which said that all British creditors would be paid the debts by American debtors. So that became the law. But the southern states hated that, and essentially southern judges and southern jurors refused to enforce British debts. At the Constitutional Convention, the southern states were pretty much opposed to the existence of federal trial courts because they feared that federal trial courts would enforce the Treaty of Paris. And so James Madison came up with a compromise, said, hey, let's just allow for the existence of federal trial courts, but kick the can down the street, let Congress decide. And so the Constitution went forward with no requirement of federal trial courts. Well, in the Congress, everyone more or less agreed there had to be federal trial courts. The option would have been to have state courts try all the federal claims. Had to be federal trial courts in order to enforce federal criminal law, enforce tax laws, and also to enforce something called admiralty law, which had to do with the high seas. Well, again, the Southerners said, we're not voting for that statute, for a statute creating federal trial courts. And so Ellsworth came up with a compromise. He said, oh, what we'll do is we will say that the federal trial courts can obviously try federal criminal law, federal tax law, admiralty, but other than that, ordinary civil cases would be subject to amount in controversy limitation. That is, the case has to involve at least $500 before the federal trial court could try it. And there were very good reasons for that, okay? But the main reason was because of common law pleading and the like, 90% or more of the British creditor claims could not meet the $500 limitation. In other words, Ellsworth was willing to sacrifice the proper rights of English creditors given them by the Treaty of Paris. He was willing to blow it off in order to obtain state support for the Judiciary Act in general. Now, when you look at the Alien Tort Statute, it said a suit by the court shall have jurisdiction over a suit by aliens for torts only in violation of the law of nations, basically, okay? No one really knows what the hell that meant, okay? I must say I've studied it in exquisite detail. But, and by the way, in Ellsworth's home state, they had a statute in Connecticut that provided a cause of action in that situation. But notice this. Do you see if it's a violation of the law of nation and it's hurting an alien? Do you see why we would want that to be tried in a federal court rather than a state court? Because a federal court would give more thought to the foreign policy issues involved in vindicating aliens' rights. And so he said, no amount in controversy. Even a small claim might be very important in terms of foreign policy. But do you see a suit for breach of contract by a British creditor in violation of the Treaty of Paris might be viewed as a suit for violation by an alien for violation of international law? And so he put in the statute for torts only, no contract claims. Again, do you see that his compromise on the British creditor cases, again, was in the background of that statute?
Thank you. And what were Ellsworth's contributions to the writing of the Judiciary Act? Why was he such a major figure involved in drafting it?
Well, the thing is, he was the de facto Senate Majority Leader and a very respected lawyer. And he really excelled in working in small groups in legislative assemblies. He loved, some people complain that he was all the time working with 2 or 3 other people on this and other people on that. He was quite a wheeler dealer in terms of legislation. But he was just very respected. Like Aaron Burr, an infamous person from our early history, was in the Senate. Aaron Burr said if Oliver Ellsworth happened to spell the word God with 2 D's in a statute, it would take the Senate 3 weeks to get rid of the extra D. He was just an extremely good negotiator, and he liked drafting statutes. Drafting statutes is an onerous job, okay? Very onerous. He liked doing that. In Connecticut, when he was in the Connecticut legislature, he drafted most of Connecticut's tax legislation. That just sounds awful to me. So he was quite willing to do the job. He worked very closely with a guy named Patterson, who was from New Jersey, and he and Patterson drafted the Judiciary Act, basically.
Thank you. And we have time for one last question. What was Ellsworth's relationship with Governor Morris?
They didn't have a lot of relationship. He did know Morris from the Constitutional Convention. He didn't, and they served together well on the Constitutional Convention, but I believe he probably viewed Morris as like Rutledge from South Carolina, someone who is not God's elect. He was here, part of God's plan. Ellsworth could work with him. Gouverneur Morris, by the way, was a great fun guy. He made a bet once that he would go over in a large meeting to George Washington and slap George Washington on the back and grab him around and say, "Hey, how's it going, George?" That was not George Washington's style, but Gouverneur Morris did that. No, the bottom line, though, is he didn't have a lot of relation. He had best relations with Calvinists. Patterson was a Calvinist, and Massachusetts people. He worked very closely with them. So.
Thank you. And thank you for this fascinating look at this not well enough known Chief Justice Oliver Ellsworth. We could have continued. We had more questions from the audience, but we don't have time for them. So thank you.
Well, I had a lot of fun.
So our next lecture is on March 19th at noon, when Jack Goldsmith will be delivering the first lecture in our 2025 series, The Lives of Plaintiffs Post-Court Ruling. His lecture will be on In Hoffa's Shadow, Chucky O'Brien, the Supreme Court, and A Son's Search for the Truth. Registration is now open on our website at www.supremecourthistory.org. Everyone who registered for the lecture will receive a survey link following the event. Please do fill it out, everyone. We take it very, very seriously. As you can see by the fact that this was the topic that we picked for today's event, we do pay attention to what you ask us to speak about in these events. And with that, we are adjourned. Thank you.